Hi, welcome to our show today. Lisa Zonder here. I'm with co-presenter Victoria Kurloff, who is a certified divorce financial analyst. Welcome to today's webinar. The topic is Expert California Divorce Tips. Don't let these mistakes derail you. I'm going to give you a moment of background on me, and then Victoria will do hers when she presents. So I am from Zonder Family Law Group, based out of Southern California. Our main office is in Calabasas, Los Angeles County. I've been a family law attorney for over 30 years. I am a certified family law specialist, certified by the State Bar of California, Board of Legal Specialization. A little bit about myself as well and where I focus my lens in my practice. I devote my energies to a holistic divorce process. What that means is I try to focus on out-of-court options for clients like mediation and lawyer-to-lawyer negotiation. Often I serve as not just a mediator, but also I consult for legal issues to those who are already in a mediation with another mediator. And finally, very recently, I've also become a certified ICF accredited coach, which is International Coaching Federation. And so when I partner with my clients, oftentimes what they're asking me for is not just legal advice, but they feel gut punched by divorce. And they can benefit from having somebody who is a thinking partner, both on their personal issues and professional goals. And like a typical thing that I get asked often is, can you help me how I show up at mediation? I feel like my voice isn't being heard, and I want to know how to show up as my best self at the negotiation table. And so with that, I'm going to launch into my presentation, but I just want to give a quick second here just to do my little disclaimer. Sorry, I don't mean to bore you, but I just need to say this. So for me and Victoria, our disclaimer is effectively we're here for educational information to try and give people some ideas about how to protect themselves and not make mistakes that are commonly made. But really, if you have specific advice that you need, you must go to your own attorney. And also, we are here in California. You can read the rest of the disclaimer. I'm not going to read it to you for fear that I will bore you. Okay, now on to the more exciting stuff. So you can get a copy of the slides if you need them. Here is the QR code. I haven't tried it, but I assume that somebody on my team has, so don't scream at me if they haven't. Okay, next. So mistake number, well, this is number 2. Sorry, let me go back and find number 1. There it is. Okay, not picking the right divorce team. So you need to know who you need on your team, right? A lot of people just assume I go to a lawyer and I'm done. But if there's a case where, let's say, you and your spouse agree to stay out of court, you agree to mediate, as an example. It could also be collaboration, it could be something else. But you want to hire a lawyer in that case who supports your mediation. So I want to give you a specific example of how services impact you as a potential client, right? So I was hired as a mediator in a particular case, and I'm not going to give you anything too detailed, so you won't recognize the couple. They're a couple from Ventura County, and mediation went really well, and they seemed to be settled. And then all of a sudden, wife said, no, I'm not feeling the spousal support amount. I need to have more. And it was an overreach in all likelihood, but there's an aggressive attorney in the background, not mediation friendly, telling her, and Victoria, I'm sure you know because you've seen these cases and had the experience with them too. She hires a really aggressive lawyer. Okay, not always a bad idea if you have a case that warrants it, maybe. She spent a lot of money. She went to family court and she lost in her quest for the higher spousal support amount. And so her mediation deal was better, and she wouldn't have spent all the money with the aggressive lawyer had she just accepted the settlement that was in the ballpark of where she needed to be. So just beware when you get a lawyer who you're interviewing who is a yes man for every single thing that you want, and they validate you, but they're not necessarily looking at the 360-degree holistic view of the case. You know them when you meet them. You know, they'll promise you to, or really assure you that you're going to get a lot more in spousal support. But I mean, the question you need to be asking yourself is like, okay, if we're both going to spend $25,000 to fight for the spousal support, and it turns out that wife's spousal support increases or doesn't increase, and it's less than the amount you're spending in total on all of the fees, and you have fee exposure, meaning you might pay the other spouse's fees, is that really a win? And I also have been in cases where judges have said things like, "Hey, if you're going to go after an issue, make sure that you're pretty guaranteed to get 5 times what you're thinking you're going to get, because if you're not going to get that, then you have to look at all the legal fees that you're going to incur there." Now that was a high conflict divorce case, and people were fighting over things that maybe had some value to them, but maybe not necessarily 5x. And by the time they got done with the legal fees, it is possible, and paying a private judge or whatever the case may be, just look at the total spend. The total spend on the divorce team is what you need to look at. And so look at your ROI, return on investment. And as I said earlier, not every case requires an aggressive divorce lawyer, right? On mild to moderate conflict cases, oftentimes you're going to be better served by somebody who's just reasonable minded, who helps you achieve a settlement. They're going to work with the financial professionals in the case and make sure that you do what you need to do to get that settlement hopefully across the finish line. In a high conflict case, right, could be different considerations. So I'm not going to speak about those in particular here. And let's go now to, oh, and as you can see on the slide too, you can see also consider hiring a divorce coach, right? There's some benefit there for people who are in a mediation process to get some support in the background. And as well, if you're in a litigated process and you're having a lot of difficulties communicating, let's say on parenting issues, right? A divorce coach can be really helpful there as well. But understand the different roles, and oh, I want to say one more thing, and I can say this in the context of mistake number 2. There's so many things that we see, Victoria. I'm sure we probably could go on and on with hundreds of these, but consider mediation and collaborative divorce as an alternative to court, right? It does require your spouse's consent, right? You can't clap with one hand. You can't go into mediation by yourself. You do need the other side to participate. And so there are other processes, including mediation and a formal collaborative process. For those who, unfortunately, like they're in a situation where maybe it is moderate to high conflict, and their only sort of option is to have a lawyer-to-lawyer negotiation, think about that as well before you start firing off all your court filings for formal motions. We now call them requests for orders. Okay, so there's that. Mistake number 3. Okay, so this is respecting the automatic temporary restraining order it's on the second page of the FL 110 form, which is the summons that accompanies the petition, the very first document that's filed, the form that says I want a divorce effectively. So once these ATROs, automatic temporary restraining orders, that's the acronym ATROs, once these are in effect, effectively what you can't do, for example, is you cannot just remove your children from the state of California. You can't cancel or borrow against or change the beneficiaries of your health or your life insurance policies, right? Just things to know. Same for auto, same for disability policies. And you can't transfer or encumber your real property or your personal property, right? In every case I have, pretty much someone says, hey, my spouse went to the storage we have, or they sold the Ducati, or they sold the motorcycle, or the toys that we have that go out on the water, or whatever. We hear this all the time. You need to read those, take these orders seriously, read these FL 110 summons, restraining orders, because they are seriously enforced. And one other thing that's on there is that you have to give notice of any extraordinary expenses as well. There's a notice requirement there. Not going to go into detail on it, but just making a point there. Don't violate the automatic temporary restraining orders. When you file the petition, you are now bound by the automatic temporary restraining orders. And when you are served with the petition by the petitioner, you are now bound by the automatic temporary restraining orders. General educational information for you. Any specific questions need to go to your specific attorney. Okay. I'm going to move on to mistake number 4, which is don't forget to request a copy of your own credit report, right? You're entitled to get this annually at no charge. And to my knowledge, it's illegal to pull your spouse's credit report. So don't do that if you don't, if you don't want to be in hot water there, don't do that. What you can do is potentially you could ask for them to produce a copy to you as part of a formal discovery demand, or if you're in a more cooperative process, they may actually cooperate and you exchange them. I recently learned about something, and Victoria, if you have anything to add here, please let me know. There is a specialty credit report option where you can get copies of more information about your banking and checking accounts. So there are companies that do that. They have this type of information, and like for almost every major bank in the country, and you can immediately see all of your banking information there on the report. And I think there's one called Telecheck. I don't know if you want to add anything there, Victoria, you're welcome to. Okay. Okay. And so let's move on. But again, the credit report can be really helpful, not just for your credit score, but also so you can see all of the credit that's out there and if anything hasn't been paid. Go ahead.
You might have access as an attorney to other databases that most lay people don't, Lisa. And so generally, like the credit report is only going to show your debt accounts. There's not going to be a breakdown of all of your different bank accounts if they're held across the United States. There's not really a central repository that you can, type in somebody's name and it's going to pop up like they have, 5 accounts at Wells Fargo or anything like that.
No, I agree. Yeah, but check out this Telecheck because it does offer a report, a specialty report. So that's something to look into. I haven't personally used it, but I've just become aware of it. Okay, let's go to divorce mistake number 5. Okay, so undervaluing. When it comes to undervaluing the income for support calculations, is it me or is this just buffering right now? Okay, it looks like technically it is buffering the slides. Hopefully you guys on the out there in the world are seeing this. But anyway, okay, so the support calculations. So here's the law on this, generally speaking, right? California Family Code 4058 addresses what income is available for child support. And I've given you a list there of the common types of income that's included. So it would be like salary, bonus, royalty, trust income, workers' comp, disability monies, unemployment. The court also can look to earning capacity of the parties. It just depends. They have discretion on these things. And I'm not going to get into detail on that. There's case law recently that came down about that, and it's not always a guarantee, although I think it's more common than not that in a lot of cases they would look at earning capacity if someone is purposefully staying out of the market and purposely not helping themselves to become self-sufficient. But lots of nuance there. I'm not going to get into that. In some cases also of self-employment, it's possible that with the aid of a financial professional that you can look at the perks. The perquisites sometimes are added back. And if they're run through the business, for example, if someone says, I'm going on vacation and I'm going to put it through my business expenses, or driving a car that they don't necessarily need for the business or aren't using, or some types of things that people do like that, maybe like loads of personal restauranting that isn't really for business purposes, then the other spouse, if it is helpful and the numbers justify it, might look with a forensic accountant or other financial professional at adding back some of those perquisites of employment. Okay, I'm going to move on to mistake number 6 and just do a quick check for our timing. Here we go. Okay, so in number 6, I've been speaking to a bunch of lenders, recently. Real estate is like a big issue that's coming up. And so for personal properties like the family residence, oftentimes like everybody's trying to grab for the house. They want to keep it, especially because the interest rate environment has changed. And so what's happening is everyone wants to grab that 3.2 or 3.5% interest rate that they got back before everything started, increasing, and now we're in the sixes or sevens or whatever the numbers are. And so there's a lot of like dispute I'm seeing in my mediation practice in particular, but also sometimes in the litigation practice about who pays, who keeps the house. And so in order to qualify for the spousal support, before you go into the negotiation around keeping the family residence, you have to have support, spousal support, that's paid for a long enough term to qualify for the home purchase or the refinance. So the lenders are saying that the underwriters are requiring that the spousal support meet at least the following requirements. They want to see the divorce documentation that shows that you've been paid for the last 6 months. And they generally want proof that is going to continue. And my understanding, and this is just my global understanding, but please speak with a certified divorce lending professional, someone who knows more about this. But generally, they want to see that happening for at least continuation of at least 36 months. Now, why is that important? Because if you make a deal with your spouse to get spousal support for 2 years or for, say 30 months, you just kind of wiped out your ability to be able to qualify for that loan if you need it to be able to keep the house. So kind of know all of these things in advance. Make sure that your spousal support is seasoned. Make sure you know what the lenders are asking, what the requirements are, what kind of documentation do you need, what kind of deal do you need to cut? Because I think that's super important for you to be able to keep the house if that's something you're trying to do. All right. And here we are at slide number 7, the divorce mistake number 7. So I just say this as a general proposition. I'm not going to belabor this point. When you get a settlement agreement or a stipulation or any document from the legal team, even, I'm going to say Victoria's going to probably nod her head and say, even a financial document prepared by a financial analyst, you are a partner in your divorce litigation, and it is incumbent upon you to look at what the professionals are giving you and make sure it's accurate. If it isn't, get back to the professional and tell them before it becomes a problem. So please review the settlement terms and the details in advance, and don't wait until it's too late and say, oh, I just noticed that you have my income stated incorrectly or something like that. So please make sure that you are partnering with your divorce team. And especially, I'm going to say, as a lawyer drafting documents, I want feedback from my clients. If I got something wrong or you want it stated differently or whatever the case may be, tell me before it gets sent to the other side or before we rely on it or before you put your signature on the document. Anything, Victoria, there?
I would just like to add that I have made this mistake myself, but I have hired an attorney and then I just stopped thinking. I was so grateful that I had someone else to help me navigate my problems, and I just called it in, and that didn't serve me. There were things that I needed to do to be a better partner so my attorney could properly advocate for me. So it just is really important that you continue to engage with the process. And as Lisa mentioned earlier, if the emotions are too strong, work with a divorce coach. They are going to be able to help you stay present so you can navigate all of the intrinsicies of your divorce so you can come out with a win-win outcome.
Yeah, that's a great point. I totally agree. That means sort of responding promptly to the divorce professionals, and especially with forensic accountants, because oftentimes you'll get back everything and it looks pretty okay. But I mean, we've all had it happen. I've sent things out for forensic accounting work and I looked at the end product and I was like, wait a minute, I'm puzzled. This isn't exactly what the client was asking us to do. And I've caught some things here and there, and no one's perfect. We're not perfect. We're just trying to do our best. But you are a partner in this process. It is your case. You have to live with the consequences. So please be attentive, and we'll try to do the same. But we ask that you step up and do the same with us and partner with us. Okay, moving on to number 8. This is one of my favorite slides because I feel like this happens over and over again, and people are so well-meaning, but we all have human reactions and emotions, and it's very common in divorce to feel this like sort of trauma. It's a traumatic experience for many, but we also make a colossal mistake, which is we look for emotional justice, right? And so we're not going to find it from a judge. We're not going to find it from the court. Emotional justice, as I put on the slide, it comes from your own resilience, not from a judge. If you need to get over the fact that someone acted badly, work with a therapist or work with a divorce coach. But if you think you're going to spend, piles of money and that somehow it's going to come out right, it's probably not. I'm thinking of like one of my favorite cases where initially I didn't know this as the mediator, but there was some act in the marriage. Let's just say that it was a betrayal, and I'll leave it at that. And I came up with this idea, and the lawyers just wanted to go off to the races and, litigate this thing, and probably would have spent hundreds of thousands of dollars for breaches and this, that, the other. And what we were able to do is have the parties come to terms on what I called an amends payment. And so maybe there is some emotional justice, some feeling of like, okay, we leveled the playing field by the time this divorce case was done. But I just want to say that there is no emotional justice. The court is just going to simply look at the facts. They're going to look at the support calculations based on the income. They're not going to award you more support necessarily, even if your spouse did something like cheat or, change jobs and it was frustrating to you, or maybe they were out of the workforce for 10 years. And now you're sitting here dealing with paying them spousal support. The court isn't going to say, well, they were out 10 years, so now I'm going to just assume they have an income earning capacity. They're not going to necessarily impute income right away. It could happen with the right experts, but emotional justice, and I put at the bottom, at what cost? So, if you play this out and you think you're going to feel better because you're going to prove that you were right and you were hurt, the truth is you may have been hurt in a divorce, but the court isn't going to really quantify that and give you a remuneration for it. So it's best to divide your assets best you can based on not combat pay, okay, for a bad relationship. There is no such thing. Now, I'm the first one to advocate that maybe there should be combat pay for being in a bad marriage, but unfortunately, I don't think you're going to find it, generally speaking, in family court, not through the fault of any judge, but just because the laws are and the case law isn't really set up in that way. Domestic violence may have its own exceptions and rules around it, so I'm just going to put a footnote there. All right, divorce mistake number 9. So failing to protect your retroactive spousal support rights. A lot of people go into a mediation and they don't realize that they're thinking they're going to have a deal, and then 6 months later and 8 months later, there's still no deal. They're in with a recalcitrant spouse. They don't know that it's never going to happen. They are a little bit idealistic and they're sort of praying on it, hoping that it's going to happen, and it doesn't. And so one way to protect yourself is to file that request for order for spousal support and what, if needed, child support, because under Family Code Section 4333, the courts are constrained by this law that says you have to file this request for order in order to get your spousal support clock running. In other words, in order to start your spousal support rights, you need to file something with the courts. The mediators don't generally go over it, and I've now put it in my written documents, advisories to clients, but they're supposed to go get their independent consulting attorneys and find that out. A lot of times when they're in mediation, clients don't ask their attorneys that. They just say, hey, I'm working on a settlement. I'll call you, let you know later how it's all going. And so that's just a mistake that people make, is failing to protect their retroactive spousal support rights. I want to give a second here. Victoria, you look like maybe you wanted to say something there.
Well, I think it's also, had a comment about combat pay. And so I think in that same vein, it's important to keep in mind when you're doing any type of division analysis, we're not going back and figuring out like all of the day-to-day financial operations of the marriage, unless there was major like fraud that was going on through the willful dissipation of marital funds. It's all about figuring out what your total marital estate value is as of that date of separation, pulling out any separate properties and making sure inheritance is held separately as well, and then dividing everything up. So it really is about the current financial picture. And as Lisa mentioned, it would be nice to get combat pay or some type of benefit for being with an abusive jerk, but unfortunately, that's just not how the court system is set up. And there's not really a way to value what that would be unless there is a gambling addiction or a drug addiction or prostitution or a mistress. And that's a whole different ball of wax.
Yeah, that would be like a breach of fiduciary duty claim, and that is possible. But you have to prove you bring your evidence to the judge on that, and those are not inexpensive to prove, and may or may not be granted because there are a lot of defenses to these things over time. Like, well, my wife knew that I was that was my hobby. I went on trips and I stayed at casinos and. So like it's just not so clear cut all the time when you get into these breaches of fiduciary duty. There is some remedy for that under the family code, but in general, just because my spouse was a jerk, that's not going to do it. Yeah. And I appreciate the point that you raised, Victoria. Thank you. Okay. And finally, we are moving to 10. This is just something I would want to say to a lot of clients that I've had, especially as coaching clients of mine. I've noticed this comes up a lot for coaching clients where they are having a very difficult time with a high conflict spouse, and they're so threatening and menacing, and they're texting at all hours, and then it feels like they're being stalked or harassed or followed to the gym or whatever the case may be, or even having the spouse show up at their door, which, by the way, restraining order realm, that's not what I'm talking about here. But there are available communication tools, and you can ask for this to be done voluntarily by the other spouse. Like, hey, let's go on Talking Parents instead of using text messaging and emailing and phone calls, right? I think the goal here is to try and keep this to a business relationship after people are filing for a divorce petition and not continuing that same relationship dynamic. There's no need to do it. And so, why would you use these communication tools, right? Maybe it costs $100 a year per party. Like, it's a little bit of an expense, but they have an ability to retain the messages so that they're available to the judge. Most of these, there are other tools, by the way. I'm just naming the two most commonly known to me. I know I've heard of others. There's also a tone meter in one or more of them, which basically will let you know when your tone is out of line. You do not want the judge seeing a threatening email on your part that shows that you are ripping the other side to shreds. You may feel better at the moment you write it, but when a judge sees that, they're going to see you as potentially like a violent communicator. We want to have nonviolent communications as much as possible, and everyone's emotions are running high. So these types of tools are available, and I would suggest you look into them. Okay, and you can get a court order, by the way. If there's no agreement, you can ask the court to order that those be implemented in the case. In this divorce mistake number 11, and we're almost to the end here, I'm going to turn this over to Victoria in a second. What is the right level of detail that should be memorialized in a settlement agreement, including parenting plans? Well, there is no one size fits all. So what I said in the title here is no more or no less detail in the agreement than what the parties need. So some clients don't need that high level of detail because they've been effective co-parents for a really long time, and they don't want every detail memorialized. And they're both abundantly clear about what they need and want. And so those parents, when they're in mediation, they just say, it needs to say 50-50 and, 5522 or whatever the number is for the parenting plan, the days on, the days off. And so we definitely expect that whatever it is that you need, we'll memorialize it in writing, but it's also in partnering with your divorce team. Let us know, because some people are so high conflict that in their parenting plans, they need much more detail in there. It needs to even say like the place where you're going to go, whether it's a restaurant or a park or a police station, not necessarily the best in most cases, but wherever it is that you're going to have that pickup and drop off of the children. So it's really important that you get the details in there that you do need to. Don't overlook that. And we'll go to our slide mistake number 12 is not considering future changes in circumstances. And so it's important to consider if you have a job loss or you retired or you're remarried or there are health issues, think about going back to an attorney and getting a consultation. Okay, don't just sit there in misery when you can't afford something and you're post-divorce and your circumstances have changed and now you're only on unemployment, or heaven forbid, people got a health diagnosis that's pretty severe and they have huge medical expenses. By all means, please go back to the court and or first to an attorney and make sure that you are letting the court know that. Victoria, you wanted to say something?
Yeah, I think it's also important to keep in mind that how long your marriage is also going to dictate what type of rights that you have post-divorce. For example, for marriages over 10 years in the state of California, and Lisa can go into this more so, but that's considered a long-term marriage, and you'll always be subject to a spousal support analysis post-divorce because of that length. As if you had a marriage under that 10 years, it would be a little different of the situation.
Yeah, and those are general rules, and everyone, it's case by case basis. It's discretionary for the court how long and how much spousal support is. And so, agreeing with you there that you've got to think about these things. When you're suffering or realizing you have a change, you've got to point it out to an attorney and ask what relief, what do I have available to me. And finally, if anyone wants to connect with us, they can basically come to our website or call our office at 805-777-7740. And with that, I'm going to ask our terrific admin, Allie, behind the scenes to take off my slides and switch to Victoria's. And I'm going to let her take it away. And thank you so much for joining us today.
Okay. Let's see. Allie, I think I can handle my presentation. So I actually have it uploaded in my side. Let's see. Maybe I'm not able to do that. Oh, there we go. No. Okay, we'll just roll with it. Well, welcome everyone. My name is Victoria Kurloff. I am a certified divorce financial analyst and a family financial mediator. My job is to help families like yourself make data-driven decisions during times of life crisis, which generally divorce is going to be considered the biggest transition of your life. And if you are not aware of the different financial implications of this, it is going to be one of the most challenging and potentially punitive experiences of your life. So getting involved and understanding how really you can navigate this with dignity and financial ease is going to be the topic of my conversation today. So a little bit about myself. I ended up becoming a CDFA after I used financial analysis to leave my highly abusive relationship. Essentially, I had a wonderful dad who was always encouraging me to be a mathematician. He would say, Victoria, if it cannot be expressed in numbers, it cannot be expressed at all. So fast forward to my life with Voldemort. I was looking to get out, but I had no idea. And I was so financially intermingled and intertwined with this man. I was frozen in fear. And I had to essentially extract myself. And the only way for me to do so was to replace my fear with financial facts. So I sat down at our computer and I typed out what ended up becoming the first global settlement proposal. And I was able to have a very effective, streamlined transition with him. We came to agreement within like 20 minutes. And we were able then to have a very peacefully uncoupling for what was a pretty abusive situation. And that is kind of how I fell into this field. I own my own business, and now I serve clients primarily in California, but I do serve throughout the United States as well. So I am going to discuss with you really the 12 financial pitfalls of divorce, and how you can get prepared and take control of your divorce process so you don't end up in divorce purgatory. So the first thing, divorce is a very expensive process. And you have to keep in mind, when you guys got married, it was an investment in your future. And that's the same thing what a divorce is, except now you have to go through the entire valuation process, because when you got married, there was something called the creation of the marital estate when you submitted your marriage certificate to the courthouse. And that was the beginning essentially of your marital company. Now, as a part of the divorce, you need to go through and value each department, so to speak, and determine who should take what asset. And it's not always straightforward, and there's a lot of different implications with different assets. So the more that you can be mindful of how the operations outside of the legal event are going to impact you, the more you're going to be able to build a cost-effective process. Depending essentially on where you're coming from and your conflict level of your divorce, there's going to be different levels of cash involved. So if you are in a high conflict situation, everything is knockdown, drag out fights, you're probably going to be in that red box, going to court, having to probably focus on the traditional methods of negotiation that are position-based. Position-based negotiation tactics are essentially win-lose based, as opposed to alternative dispute resolution models like mediation and collaborative divorce that are focused on the person's interest. Interest-based negotiation asks why, and it really helps you build good settlement proposals that are considerate of each person's needs, as opposed to litigation, which is really designed to prosecute criminals. It's not designed for family law. And Lisa can speak a lot more eloquently on how challenging it is to get some cases through or over the finish line in a litigation matter. But there are so many different ways that you can proceed forward with your divorce if you're aware of the different legal models of uncoupling that are going to meet your family's needs best. For example, there's collaborative practice right in the middle. This is kind of a good blend between mediation that takes a very unbiased approach, where generally most parties have a consulting attorney outside of the negotiation, but there's actually a lot more work that you're going to have to do in a mediation as opposed to a collaborative divorce where there's more teams. So, with that, obviously, the more principal or the more professionals that you involve in the team, it's going to cost more. So making sure you have savings set aside, using, if you have to use a HELOC, really make sure that you can afford to do so. Credit cards are always going to be the last resort. You can take a loan from your 401k. However, most of those do have to be paid back. So if if you're in those initial stages of the divorce planning process, I always recommend saving anywhere from $15,000 to $20,000. You might not need it, you might need more, but you actually have to, pay your professionals to then advocate for you. And if you hire the right team, it will be so much more streamlined. You'll be able to have a really easy process, but there is a lot of work that's involved in selecting the right team and model. So the second financial pitfall is not enough preparation. There are so many different areas of your life that are going to change, and you really need to be aware of that before you take a concerted effort forward. Document all of your financial facts. Understand those variables. Talk to an attorney. They are going to be the best person to advise you on all of the legal rights that you may have. A lot of times in mediation, families deviate from what is case law, and they do what is based off what works best for them based off of what it works in their family dynamics. So, but those plans always begin with a little bit of case law. So you want to make sure you have the right knowledge base before you agree to anything. Another important thing is making sure you have the timing accurate. I do a lot of gray divorces. So that means part retirement, part divorce. And so you want to make sure if you are qualifying for the divorced spouse Social Security benefit, you have the right amount. You have to wait essentially 2 years before you can qualify, and you have to be divorced. So there's a lot of timing plays that come into fruition as you're navigating all of the economic triggers that go along with your divorce process. Another important thing to consider are all of the important items that you have delayed, from getting your teeth crowned to, getting the chimney swept out, repairing the roof. All of these things, if you can do that during the divorce or prior to filing for divorce, those will be paid out of community assets. Now, I'm not saying run away to Aruba by any stretch of the imagination, but if there is delayed maintenance that you have put off, do it now. Especially when you're looking at that marital house. This is one of the most hot button items in your divorce. But let's say you have an old house, the air conditioning's crap, there's some other issues. Maybe there are some foundation problems. These are things that if you keep the house, you are going to have to repair it along the way. And if you do it during the divorce process or prior to so, you'll be able to split those costs over the marital estate, so you're not stuck navigating those costs post-divorce all on your own. This is really granular, and so with divorce, you always have to keep in mind there's going to be a lot of different strategies for you to implement, and that's where understanding all of your different options, it's really going to help you maximize this divorce settlement so you can do what's best for not only yourself, but your future self and family. Something else that's important to do, a lot of us have, once the divorce process gets going, it is very overwhelming, just because generally it's the first lawsuit you're encountering. And then you also have all of the emotions of the relationship that's uncoupling to navigate. And little things are going to kind of get swept under the rug. I was working on a case, and the gentleman, they ended up having a bunch of personal property, right? And I asked him a couple of questions as we were reviewing his marital balance sheet, and he had just put like a line item, like he had these amazing Super Bowl rings, and it had no value. And it turned out that these were like worth $50,000. And he was just going to give them away to his wife as, trying to equalize the estate. But it wasn't accurately represented because that value was not there. And so she was actually getting a lot better deal in the end, about 65% of the marital property when all of these different additions in their personal property were added to the equalization. And so the more you can really dig deep and build out that marital balance sheet, it's going to help you really articulate your proposal to the other side. And if they're getting a good deal, it is going to show up in the numbers.
Hey, Victoria.
Yes.
Just to comment on something real quick, you said the gray divorce, and it just made me think too. I've had a couple of cases recently that I'll call the white divorce, where I have people close to their 80s and so on. And I just want to say that oftentimes you're going to need to have like a crossover with an estate planner. And there may be Medicare, Medi-Cal issues about, a spouse going into senior care living. Maybe they need some medical support and assistance. So, we really have to think about, people going through divorce at any age, and there are unique considerations there. And I just wanted to chime in with your gray divorce comment. Yeah.
Oh, absolutely. In fact, those gray divorces and white divorces, as you pointed out, Lisa, it is even more important to have a financial professional involved, because this is not an easy split normally. There's retirement implications, tax consequences, and a whole host of estate planning issues, especially if there's money involved. The adult children, they might have issues surrounding this. And I have seen it, unfortunately, where if the estate planning documents do not get updated after the divorce, it destroys the family. So it's very important that the right professionals are engaged. a lot of people don't realize they're little businesses. We own our assets during our life and it's not that big of a deal. But then when you either have to retitle them from a divorce or from a death, you then have to encounter the invisible legal infrastructure that supports all of the framework. And that's really what the divorce process is designed to do, is to do that financial uncoupling. So leaning into this, and really leads us to the third financial pitfall, which is not having documentation. And this is a huge concern of mine for my clients that have separate property. If you are making a separate property claim, you need to have your account statements from the date of marriage. That way you can actually prescribe to the value, what it was when you got married. So you can pull that out of the marital estate. If you don't have that documentation, unfortunately, you're going to be reliant on your partner's goodwill to grant you that accordance. Potentially, you might be able to go to a financial institution, but most of them, they liquidate their record keeping after 7 years. So this is really important. And a lot of people don't think when I get married, I'm going to get divorced, or I need to do a total evaluation of my marital estate or my separate property estate as I enter the marriage. But if you don't have that information, it can be very hard to, go back and figure out how much money was separate. And then it becomes just contentious. And if you're able to have that documentation, even with a high conflict partner, you bring their financial, conversation back to reality, and you keep everything moving forward. So you're not having to deal with magical thinking and estimations. Estimations in divorce are going to destroy you. Never estimate your budget. Never estimate your balance sheet. These are key documents that make up the financial affidavit. So what the financial affidavit is essentially helping you comprise the total picture of the marital and separate property estate values. There's two different documents in the state of California. Family or FL 142, it's the schedule of assets and debts. So this is going to be everything you own and everything you owe, from your house all the way down to your retirement accounts. Really, you've got to build out 142 with documentation. And it's important that you use the date of separation for any account. If there's ongoing shared accounts, maybe use the current market value if it's been going on for a period of time, the divorce has been. But you need to really tighten down your valuation dates so you can come up with the total value of the marital estate to complete that. So the next document of your financial affidavit is FL 150. Now, this is essentially your budget, your income and expense declaration. As Lisa was mentioning earlier, in the state of California, for child support and temporary spousal support calculations, side note, permanent support is differently calculated than temporary. That's another topic, though, for a different slide. So when you're doing your child and interim support calculations, they're really focusing on the total amount of income available for support. There's a few different deduction lines, but it's produced by a program called a DisoMaster, and it's a computer-generated calculation. And if you don't go through and properly determine your income. And as Lisa mentioned earlier, if you're a business owner, if your spouse is a business owner, there's something called a perquisite. And this is a business paid personal expense. It is a form of non-cash compensation. And it also needs to be added back into the recipient's total income available for support. So really understanding just all of the intrinsicies of your financial picture is going to help you build out the most effective and maximized support calculation. Another important thing, if you are trying to build out your marital balance sheet, a lot of us don't actually have an ongoing document of all the stuff that we buy. I know I don't. I probably should. But you have to begin somewhere. And that generally is your tax return. Now, keep in mind, divorce financial accounting is 100% different than IRS accounting. When you are building out your tax return, the whole idea is to lower the amount of taxable income that you have. When you're doing divorce financial accounting, we are looking at the total amount of income. Some of it might be taxed, some of it may not be. And so the tax return is a good place to begin, but then you need to take it a step further and actually drill down on those individual documents. It's also important to note that your tax return doesn't have like an itemized list of all of your different bank accounts. It's only if it kicks off some amount of income that has to be taxed. So what this might mean is like your 401k, unless you took a distribution prior to age 59 and a half, or if you're in retirement taking those distributions, it's not going to generate a 1099-B form. So it's not going to be listed on your tax return, but it is an asset you have. So keep that in mind as you're building out your marital balance sheet. It's a good place to begin, but then you got to drill down further. Financial pitfall number 4 is overlooking assets. Now, keep in mind, no matter what he has said, half of everything is yours that you've accumulated during marriage. So oftentimes this means like weird little unique assets, anywhere from like your credit card miles all the way up to like a sick pay and paid time off. This can be valued and it should be added back into the total marital estate so it can be adequately divided amongst both of you. It's also important to keep in mind any type of weird collections. As I mentioned earlier, those Super Bowl rings really changed the divorce settlement, but artwork too. So take the time to look around your house and determine, what the value is of everything around you and build that into your personal property inventory as well. If you guys have a business, this is going to be valued differently. It's not just based off of how much money is brought in. There's a complex process, but it also varies based off of what type of business you have. So a solopreneur business is going to be very different than a full-blown corporation. And, engaging a business valuation expert is going to help you really drill down on an estimated value. But unlike a retirement account where you can go look and see the exact value based off of what the market is trading on that day, a business is not like that. And it can be a range of values. And generally, there's some element of something called goodwill. Goodwill is intrinsic or is an intangible value, and there's no really way to ascertain what that would be. But essentially, it is a value that is placed on the brand's reputation, the time in market, the experience the client has, and it can wildly vary based off of your valuation expert in one arena versus another. So the more that if you have the opportunity to be amicable with your spouse and potentially work with one financial expert instead of going the litigation route and individually hiring one person for each party, you're going to end up with a lot more competing facts, and both parties probably will have an relatively accurate value, but you're going to have to double the pay. So if you can work together, you can really use the financial facts to make the rest of your negotiation process streamlined. Retirement plans are another thing that often gets overlooked. First thing, not all retirement assets are created equal. So what that generally looks like is a 401k account that is traditional is going to be taxed differently than a Roth account. So with a Roth account, that is funded with post-tax dollars. So it grows completely tax-free. And when you pull it out, no taxes are owed. However, with a traditional 401k account and a traditional IRA, those are funded with pre-tax dollars. So what that means is the government gives you a tax break now, but then and when it grows, it's not taxed. However, when you pull it out, the government is going to tax you at your ordinary income tax rate. So that can be a hidden tax bomb. Oftentimes, I will see this manifest as someone makes a proposal to take on $100,000 of the Roth account for themselves, and then they're going to be generous and give you $100,000 of the 401k. Well, in actuality, that 401k is worth $70,000 and the Roth is worth $100,000. So they're not actually being that magnanimous now, are they? So understanding those tax implications, that's really going to help make sure that there's no divorce bombs in your settlement. Another important thing is I mentioned earlier that there's the divorced spouse Social Security benefit that as long as you have been married for 10 years, divorced for 2 and are 62 years old, you are eligible for up to 50% of your spouse's benefit or your ex-spouse's benefit with no impact to them and their benefit amount, or 100% of your own, whatever is greater. Now, Johnny Cash famously had 3 different women on the divorced spouse Social Security benefit. And so it impacted him nothing. He didn't have to pay for it at all. So this is something that when you're doing a gray or a white divorce that you need to kind of build in, especially if you are doing long-term spousal support calculations and building those economic triggers into that schedule. Another important thing is how you divide a retirement account, a qualified retirement account. So that's going to be from your employer. That is going to be done traditionally through a quadro. So there's just an additional process that you have to do post-divorce. With an IRA, you would not have to generally do so. Number 5 is ignoring the tax consequences. I kind of mentioned a little earlier how the 401k is different than a Roth account. And if you aren't aware of that difference, you could be left, with a $30,000 difference. So that's important to keep in mind. Also, if you guys have any real estate properties, any depreciation needs to be factored into a settlement. When it comes to support, child support is never taxable. Alimony or spousal support is not at the federal level, but it is at the state. And that generally, I think it's around 8 or 10%. So just being mindful as you are building out your budget blueprint, factoring the right tax consequences will really help you make sure that you're not going to be underwater post-divorce. Now, skip through that since we're kind of running a little short on time. Financial pitfall number 6 is believing ignorance is bliss. It is an overwhelming process, no doubt, to go through a divorce. So you just have to keep in mind to build your team, but also this is not designed to be fair. Unfortunately, it stinks. You generally are going to have to do the majority of the heavy lifting, especially if you are dealing with a high conflict spouse. Getting your financial facts in alignment are really going to help you streamline the rest of this so you can be an active player. This is a challenging process. As you can see, based off of that original chart, there's a lot of different legal divorce models that you can go through depending on your situation. And if you are engaged in the process and you are really taking a strong role in this, it is going to save you a lot of money and you could avoid litigation. Maybe you can do a collaborative divorce instead and really help your family through this peacefully. Do you have something to add, Lisa?
End of our time. So we're getting close to end of time. That's all.
Okay. Well, how do you want me to end it? Do you want me to kind of jump through the last of the slides or just wrap up?
No, go ahead and jump through a couple more slides. I think we still have a little over a minute.
Well, the 7th pitfall is mixing money and emotion. I oftentimes see my clients fail to understand their attorney is not trained in personal finances or emotional regulation tactics. Their job is to be the best linguistical warrior for you, but you need to, show up with your divorce report in hand and then also have those emotional regulation strategies that you've developed with your divorce coach so you can work with your attorney to really get you the outcome that you desire. It's also important to keep in mind that the divorce process is not designed to punish anyone. It's all about helping you guys separate peacefully as possible and making sure that not one person is like driving a Pinto and the other is driving a Tesla. This is about, generally a decrease in lifestyle for both parties and trying to figure out how to make this work. Now, there are so many things that I can share with you, and I want to be mindful that we don't have that much time left. So I'm just going to skip to the end. I would encourage everybody, though, to get good advice. I think that is the most resounding theme throughout Lisa and my conversation today. If you are not working with the right professional at the right time of your divorce, it's very easy to get bumped off of track and to maybe chase after, something that is not going to have the highest probability of occurring for you. There is so many things that you can be doing to focus on building your future. And when you are building the right divorce team, you're going to have a guide that's going to help you really make this process as streamlined so you can get to living your best life. The divorce is not about anything other than helping you rebirth and renew who you truly are. And once you understand that, you're able to really attack the individual phases effectively and efficiently so you can move on with your life. And with that, I thank you so much for your time. I'll kick it back over to Lisa. I'll put my information's up here. But I would recommend, if you guys have any more questions or would like more information about me, head over to my website, divorceanalytics.com. Thank you so much for your time.
Thank you so much, Victoria. And thank you everyone for joining us. I hope this gave you some tips to avoid making some of the common divorce mistakes that folks out there make. Hopefully this has been helpful for you. We really appreciate you watching our educational webinar, and thank you everyone. Bye-bye.